Hi friends, now we are with amendments which is applicable for this May section examination. So first we will start with Negotiable Instrument Act. So in Negotiable Instrument, the important amendment is check drawn in electronic form, electronic check. Okay, check. So what is a electronic check? A check which is drawn by using computer resource. The check which is drawn which is using computer resource and which is signed by a secure system which is called digital signature or electronical signature. And what technology they will use, asymmetric crypto system, asymmetric crypto system. This is the technology they will be using for this digital signature. So this is the technology which is used for this check which is drawn in electronical form. So check drawn in electronical form is drawn via computer resource and signed by a secure system, that is digital signature or a electronic signature, and asymmetric crypto system. Then this is the first amendment, and the second amendment in Negotiable Instrument Act is which court will try the dishonor cases. For example, if the check is presented for payment and if it getting dishonored, the banker of the payee, that jurisdiction, it will be tried. The offence will be tried under the jurisdiction means the area which court will try this offence. So the area in which the payee has presented the check. In case if it is delivered for collection, then the the local jurisdiction of the bank where the payee maintains an account. Okay, this is the difference between the check presented for payment and the check which is sent for collection. So in the case of dishonor while presentment of check by a payee, so the jurisdiction of the bank, okay, on which the payee presents, that is the drawee's bank. Then so because over the counter they will be given, that is check presented for payment, then it's sent for collection, then is a payee maintains his account in which bank, that bank jurisdiction it will be dealt. If a payee puts more case on the drawer, the case where he puts the first case, no, means like the court in which he puts the first case, it will try the offence of the subsequent cases. Now previously it is not so. Now if the all these cases has been transferred to a concerned jurisdictional court, now all this concerned jurisdictional court only will try the subsequent cases. This is what the amendment. Now if it comes to bonus act, bonus act, the employee definition which is earlier was just 10,000 rupees, now it has been increased to 21,000 rupees. So then minimum bonus, earlier it was 3,500 rupees, now it was increased to 7,000 rupees. Now we will come to Companies Act 2013. What are the amendments? In case a person contravene the provisions of 1% company, in case the person contravenes the provision of 1% company, then the fine is 5,000 rupees one time and 500 rupees for continuing offence. Okay, so it's a 5,000 rupees for one time and 500 rupees for continuing offence per day. Then then the next amendment is they have withdrawn the paid up capital requirements for a private company and a public company. That 1 lakh rupees and 5 lakh rupees paid up capital requirement has been, no, it has been withdrawn. So it is not required for a private limited company to have minimum 1 lakh rupees paid up capital and public limited company to have 5 lakh rupees paid up capital. Then common seal, which is required to be affixed in share certificate, dividend certificate, etc. Now common seal itself, the concept itself now became an optional concept. The common seal itself became an optional concept. So it has been withdrawn. The common seal which is mandated to required, no, that has been withdrawn. Then commencement of business certificate has been withdrawn. Okay, it is not required for now the company to have a commencement certificate to operate. Next, in case if the company, the next amendment is, it is a penalty amendment. In case the company is failed to repay the interest on deposit or fail to repay the deposit itself, then the penalty is now 1 crore, which may extend up to 10 crore for the company, 1 crore to 10 crore for the company, and for the officer it is 25 lakhs to 2 crores, along with for the officer imprisonment 7 years. And if fraud is proved against him, then section 447 will be attracted. This is what the punishment. So for the company 1 crore to 10 crore, for officer 25 lakhs to 2 crores with 7 years imprisonment, and if fraud is proved then 447 applies. Then amendment for section 8 companies. For section 8 companies, what is the company which is formed for non-profit organization, non-profit business. First, the board can decide where they want to keep the general meeting, provided in case if the members has given any instruction for keeping general meeting. Generally it has to be kept in the register office or the town or city in which the register office is situated. If the general body, that is general meeting, has given any decision, then the board has to obey it. Then previously 21 days notice should be sent, no, for all the companies. For section 8 companies it was reduced to 14 days notice, so 21 days became 14 days for section 8 company. Then minute section is not applicable for section 8 company. That AGM minute section and also not applicable for section 8 company, provided if article authorize them to maintain, then they have to maintain the minutes. Then government company, what is the amendment made? Now the government company, like a section 8 company, they need not use the word the private limited or public limited at the end of the government company. Okay, previously section 8 company was using the means they have withdrawn, means they can give an exemption that the word private limited or public limited need not be used, no, like that government company also will not be using the word private limited public limited at the end. Then the section relating to beneficial interest, investigation of beneficial ownership and all is not applicable for government company. So that beneficial ownership section itself not applicable for government company. Then for conducting AGM, the place can be decided by the board in consultation with the central government. So where the government company's AGM will be conducted will be decided by the central government also. Now next, exemption for private limited companies. The private limited companies can have differential voting right shares. So they have that variation in voting rights. It's not all the shares require equal voting rights and equal dividend rights. In the case of private limited company, they can have differential voting rights. Then for the rights issue, generally they have to keep for minimum 15 days open. In case of rights issue, all the companies should keep the rights open for minimum 15 days. But it is not required for a private limited company in case 90% has authorized it. 90% of the shareholders of the company has authorized that they need not keep for 15 days. Next, employee stock option, whenever they are giving for all the companies, agent generally require special resolution. For private limited company, that has been modified into ordinary resolution. So how many shares you are going to issue for employees, now it's an ordinary resolution itself. Then restrictions on buyback for private limited company when they are providing loans to employees, no, this and all, these restrictions are not applicable to private limited company. That employee loan restriction. Then the next amendment is if they are satisfying the three conditions. The condition number 1 is paid up capital is not held by body corporate. Then condition number 2, loans does not exceed 2 times of the paid up capital. And condition number 3 means loans not exceeding 2 times of the paid up capital or 50 crores, whichever is less. And condition number 3, this loan has not been defaulted. Then the private limited company can accept loans from members up to 100% of the paid up capital and free reserves. This is the next amendment. So it's like a deposit amendment. Deposit section 73 section is there, no, amendment there. So private limited company can accept deposits from members up to how much? 100% of the paid up capital and free reserves, provided these three conditions are satisfied. What is the condition? Condition number 1, paid up capital is not held by body corporate. Condition number 2, loans does not exceed 2 times of the paid up capital or 50 crores, whichever is less, and this loan is not being defaulted by the company. In this case, they can take deposits from members. That means it's exempted from deposits itself. Then the articles of association of a private limited company can relax the provision relating to meetings. The 21 days notice and all required, no, that and all can be reduced by articles of association. Then explanatory statement. It is not mandatory for the private limited company to send explanatory statement when they are sending the special notice, and if it's required by the articles of association, then they have to send. So it's all given to articles of association. Then quorum also, they have to maintain the minimum two, but that maximum can be extended by the articles of association. Proxy and restrictions of voting rights, okay, in show of hands, polls, etc. This can be decided by the articles of association itself. Then the section 117, which talks about resolution which requires to be filed with ROC. Section 117, which is the resolution which is taken by the board of directors to be filed with ROC, has been withdrawn for private limited company. So private limited companies board resolution need not be filed with ROC. Next, the next amendment is NCLT till it comes. For example, the November section exam NCLT is not yet applicable, so you have to write CLB, that is company law board, which will be taken charge. So wherever tribunal word is there, you have to write like a CLB. Then the person who wants to give special notice, okay, to the company should be holding at least not less than 1% of the voting power, or not less than 5 lakh rupees of face value of the shares. Previously it was mentioned more than 5 lakh rupees. Now they have amended to not less than. Okay, that means 5 lakh rupees or more. Okay, not less than. So they can give special notice if they want anything from the company. They can give special notice. Then the company can receive loan from directors and relatives, provided the directors and relatives are giving a declaration that these loans are not borrowed loans. So company can accept the deposits from directors and their relatives, which is not considered as deposits, provided they have to give a declaration that it is not a borrowed loan. Then the company can issue now debentures, debentures, secured debentures they are issuing. They have to be redeemed within period of 10 years. If they want to issue a debentures which is more than 10 years period, which can be up to 30 years, few companies can be done, which is infrastructure companies. So only if the infrastructure company, then they can have more than 10 years up to 30 years of redemption period. Other companies 10 years. Then in case of the documents, which is, we see, if the company wants to get incorporated, they will be submitting forms to ROC. If the ROC find any defect in the form, they will be asking for resubmission. Like that, they will be again they will be resubmitting. Again they finding defect. Like that, how many times resubmission is allowed? 3 times resubmission can be allowed. So this is the amendment. 3 times resubmission can be allowed. So these are all the applicable amendments for November section exam. Okay, in case you have any query, then you can WhatsApp me at 99405 so you do only WhatsApp. Okay, and if you like this video, please subscribe. So you can see the subscribe button in the YouTube, then please subscribe. Thank you so much. Bye bye.